Imagine this. A parent dies, and when the will or trust is read, one sibling receives everything. Maybe you were completely disinherited. Maybe your share was reduced. Or maybe you've been kept in the dark about what's happening with the estate. Your first instinct might be to fight. But every year, people file probate petitions because they feel what happened to them was unfair, wrong. However, judges don't see it that way. They don't choose which cases they hear based on fairness. They hear cases based on whether you've met three legal requirements. So, before you spend thousands of dollars on a probate attorney, only to have your case dismissed, let's run your situation through what I call the three requirements test: right time, right person, right place. But before we go any further, let me quickly introduce myself. My name is Angelique Kamani. I'm an educator and not a lawyer. I am someone who had to represent myself in probate court when I couldn't afford a lawyer. This video is for educational purposes only and not legal advice. When I say the right time, I'm really talking about the statute of limitations. Basically, the question is, are you still within the deadline to do anything? Because in probate court, you might be right, but if you're too late, the judges can't help you. Most people assume they can challenge a will or trust whenever they discover something suspicious. But probate disputes have strict deadlines. In California, many disputes revolve around a 120-day rule. For example, if a will is admitted into probate and you believe something is wrong, the law allows you to object before the will is admitted or to challenge it within 120 days after it's been admitted. That deadline comes from California Probate Code Section 8270. Trust disputes have a similar timeline, but the 120-day clock usually starts when trustees send a formal notice, often called a notification by trustee, to beneficiaries and heirs. That deadline comes from Probate Code Section 16061.7. However, there are exceptions, especially when notice was never given. But the key point is this: the courtroom door never stays open forever. And if the deadline has already passed, you might be out of luck, even if you're right. But keep in mind, timing is not the only requirement to be heard. There's a second requirement. You have to be the right person to bring the case. In law, this is called standing. Standing basically means that you stand to gain or lose something depending on the outcome of the case. California Probate Code Section 48 explains this concept by defining who the law considers an interested person. For example, an interested person may be an heir at law, such as a spouse, child, or sibling, a beneficiary named in the will or trust, someone who appeared in an earlier version of the estate plan but was later removed, or a trustee, successor trustee, or executor because they may have legal duties tied to the trust or estate. The key thing to remember is that the definition isn't fixed. Whether someone qualifies as an interested person depends on the specific issue the court is being asked to decide. But here's a simple way to think about standing. If the court fixes the problem by invalidating the will or trust, and the estate is treated as intestate, meaning there is no valid will or trust, does money move into your pocket? If the answer is no, the court may decide you are not the right person to bring the case. And without standing, the case may be dismissed before it even begins. Now, let's say you are within the deadline and you are the right person to bring the case. There's one more requirement that must be met. Are you in the right place? And what I mean by that is, do you belong in probate court? For me, when I first started going through this process, I didn't even know what probate court was. I just assumed there was one court. But it turns out there are different types of court. There's family court, civil court, criminal court. And then there's probate court. Probate court doesn't just deal with administering estates, meaning carrying out the terms of a will and distributing the assets. It also handles litigation, which basically means legal disputes about whether a will or trust is valid or how it should be carried out. But if you're unhappy with the outcome or feel the terms are unfair, that alone is not enough. Probate court is not designed to resolve hurt feelings. It's designed to resolve legal grounds related to probate litigation. Some of the most common legal grounds include things like lack of capacity, meaning the person did not understand what they were signing; undue influence, where someone pressured or manipulated the person into changing their estate plan; or fraud or forgery, meaning the document itself may not be legitimate. There can also be issues involving breach of fiduciary duty, where a trustee or executor mismanages the estate or hides information. But if none of those legal grounds apply, the court may decide that probate court is not the right place for the dispute. So, before you spend thousands of dollars on a probate attorney, stop and ask yourself these 3 questions. 1, are you the right person to bring the case? 2, are you acting at the right time, meaning within the statute of limitations? 3, do you have the right legal grounds for probate court in California? If all 3 requirements are met, then you may have a probate case worth exploring. By knowing you might have a case is only the first step. The next step is taking a closer look at your situation. If you'd like help thinking through that, you can take my free quiz linked below called Do You Have a Probate Case? It walks you through the same questions we discussed in this video, and it helps you start evaluating your situation. You'll also receive a free probate evidence checklist to help you begin gathering the documents and information you may need.